friends. So we have a brief video, fingers crossed, on my favorite concept, which is selective incorporation. Although I am going to warn you, it is a little more complicated. Some would say this would be the hardest thing we learn all year. So it would be in your best interest for you to stop and get out some paper for taking notes. Okay. With that being said, before we jump into what selective incorporation is, I want us to think briefly about all of the things that the government gives you. So some of the things the government gives you, they're required to give you, and some of those things are they elect to give you. We're going to start with the ones that the government's required to give you. Those are your core rights and liberties. They are found in Amendments 1 through 9 of the Bill of Rights. Some of them are very explicit in what they require, and some of them are vague. The vaguest one being the Ninth Amendment, which essentially is a ability for us to find amendments because we don't want to limit our amendments. That very act of limiting them can be a little disastrous. So the government is going to deal with these core rights and liberties in 1 through 9 in two different ways. Essentially, if you do something wrong, there are some things they have to do. And if they require something from you, there's something they have to do. Those are our two classes of actions. In the first one, if you do something wrong, if you've been accused of something, then you will expect that before we remove your ability or your right to life, liberty, and property, that first the government is going to make sure that they are giving you your due process rights. And those due process rights are things like being able to question your accusers and interview the witnesses and know what you've been charged and be able to have a fair and speedy trial and all of these things. And we're constantly trying to define what this precisely means as we move through the judicial system. So once the government has respected all of those rights in a manner that is the standard, then they can remove your right to liberty. They can jail you. They can put you on house arrest. They can even take away your right to life. They can, put you to death. The government also will remove property on occasion, especially if they can prove that that property that you own serves a better purpose for the public. That general welfare concept. And when they do, it's called eminent domain. Now, eminent domain, again, requires due process rights, and you have to be justly compensated for what property has been taken away from you. So sometimes that's going to show up when we're doing things like widening highways. We're going to have to take people's property for them and prove that it serves a better purpose for everyone if your property, instead of being a farm or a house, is a highway. And those are your core rights and liberties. Now, there's a greater sphere of things the government gives you, and we call them privileges and immunities. And privileges or immunities are things that the states elect to give you, and they're benefits for your citizenship. So where core rights and liberties are things that all humans are entitled to in the courts of law in our government, privileges and immunities are things that citizens are allowed to have. And so they classify privileges and immunities in all different ways. Things like being able to move about without having to prove identity, being able to access the courts, to own property, to get married, to get divorced, to adopt, to be able to have a license to operate a motor vehicle, to be able to get in-state tuition. All of those things are privileges and immunities. The one that's the most interesting, because we're still trying to figure out where it is, actually this is a more modern discussion, is your right to guns. Is it an essential core right, something that is granted, that the citizen is reserved for themselves, or is it a privilege and immunity that the state gets to determine whether or not you have access to firearms because they're trying to defend themselves? And the defense thing, if you see it as a defense thing, then that means that the state has a higher likelihood of being able to remove your guns to be able to provide security, as opposed to, just you on your own. So once we talk about that, then we want to look into what the government, when we challenge the government for violating due process to life, liberty, and property, the courts are going to examine these actions on two different levels. So if they take away life, liberty, and property by law, by the way a law is written, and it is in conflict with the Bill of Rights or the Constitution, we're going to challenge that on a substantive due process claim. if the government takes away life, liberty, and property through its action, then we're going to call it a procedural due process claim. And so, because it has to do with the way it was, the procedures that were put in place, not necessarily the law. And we also are going to take a look at these claims against the government on the basis of different classifications. Certain classifications have more requirements of the state to prove that they're doing something that is not unnecessarily impinging someone's life, liberty, and property on this class. That sounds like a lot of gobbledygook, but it really essentially means that if the government is doing something with classifying you by your race, which is one of the most protected classifications because of our history, they have to prove that they are doing this, that it's absolutely essential, that it's done in a way that has the least impact, and that there's no other way that they can deal with this issue. So we run a test for that. It's called a strict scrutiny test, and government usually fails when someone has a claim against the government on the basis of race. That's our big one that you would see in a strict scrutiny claim. And again, you apply strict scrutiny whether it is substantive or procedural due process in the way a law is written or in a way a law is executed. We have two other classifications. I'm going to stick to rational basis, which is the lowest threshold. So the government has the right to classify you on the basis of property owner versus non-property owner, or college student versus something else. And that has the lowest threshold. So the government has the ability to kind of impinge life, liberty, and property in a manner that's more expansive because they don't have to prove as much that this is essential. Because it's not a suspect classification. It's not one that has a history of horrible things associated with it. So remember that as we move through this, because we're going to start talking about some of our amendments. So we're going to go first to the Fifth Amendment. And the Fifth Amendment talks about your right to due process. So before I get moving here, I need you to understand the Fifth Amendment is a contract, yes, but it is a contract between you as an individual and the federal government only. So the federal government has to prove that they have not taken away life, liberty, and property without these due processes of law, like things that are owed to you in a court, right? All of those things that we talked about in the first 9 amendments. This applies to the entire federal government, and it is the origin of this concept of substantive due process, where they're considering, the courts are weighing how much your liberty, how much your property or your life has been unjustly impinged. Today, we see this also being carried out in the states, but we're going to talk about how the states got caught up in this as we go through this discussion. So again, Fifth Amendment, really important for us to remember, contract between you, the individual, and the federal government only. So these ideas of what constitutes, how do we know if the government is classifying us on a suspect classification and we have heightened protections from government action versus a non-suspect, race versus student? This comes from years and years of judicial interpretations of the Constitution, and they change, and they've been changing. I told you a minute ago about the Second Amendment. We don't know if it's a privilege or immunity or if it is a right. So these things are constantly evolving because of our system of common law decisions, where we kind of allow for flexibility in the system. All right, so our first case that we need to know is the Barron v. Baltimore case from 1833. This is a Marshall Court decision, John Marshall being our favorite Supreme Court justice. He was the one who did the most to kind of set precedent for the court and how it's structured. What we are going to get out of this is that the Marshall Court is going to have a very narrow interpretation of the Fifth Amendment, right? They're going to read it exactly how it's textually presented. This case is a citizen of Maryland suing the city of Baltimore, which is essentially like suing the state of Maryland in court because they had regraded streets around his dock, his wharf, and the construction project and all the runoff from the rain actually made the sea at the bottom of his wharf shallower, so now his wharf can't receive tall ships and he can't make any money. So his right to property, his life, liberty, and property is being taken away. He wants just compensation. He wants the city to make amends, either to dredge the bottom of the bay or to pay him for his lost business. And the court is going to say that in this case, no. Constitution and the Bill of Rights were created only by the federal government and by the people, and that there is a separate statute that is out there. It's the state bills of rights that are going to navigate how the states and the individuals will work, right? So if you want to sue John Barron, fine, but you have to go through a state court because it is a state obligation, and maybe they define due process differently in the states. And so that kind of highlights one of the problems that we have here, is if we have a federal Bill of Rights and we have several states' bills of rights, and they have the same language, but they don't have any connection, they don't have a bridge that makes them the same standard, then what we find is that depending on which level of government you're dealing with will determine what kinds of due process rights you have. And that sounds confusing because it is, it really is. So for the person, depending on what state you're in, you really are going to have to pay more attention to what the legal requirements of due process are in Maryland versus the federal government. So Barron v. Baltimore is going to draw a very fine line, a very deep line between states and the national government in terms of what we are obligated to receive from them. So the next case here is Scott v. Sanford. I know we're familiar with it. Dred Scott, an enslaved person, was purchased, went up to Missouri territory, believes that he was free, believes that he has standing after Dr. John Emerson dies to sue John Emerson's wife, his widow, for back pay, because he wants to be able to purchase his freedom and his children and wives' freedom. So he believes at that moment that he crossed over the boundary, he's allowed to go to court. Again, standing is critical here, and that he should be able to sue for his property, his due process property rights, to get back pay, to be able to effectively take care of his wife and children's liberty and life due process rights. And I know this court case is really, it's controversial, right? It strikes down the idea of having the Missouri Compromise, where we can't have slavery north of 3630. It says to Dred Scott, you're not a citizen, you don't have standing in court, you're not even allowed to be here. So this case is dismissed essentially. But they also went on to say that, not only is slavery there, but they're going to grant substantive due process rights, right? That's required by law to the slaveholder, to Emerson's wife, saying that she has the right to be able to kind of protect her property, and that the court can't take away her right to property, that's Scott and his family, without compensation to her. And the court is not in a position to give compensation. So there's a lot of things that are happening in this court case that are controversial. So we have the Second Constitutional Convention. It's the 14th Amendment, and the 14th Amendment changes everything. I talked to you about how the Fifth Amendment has a very real limitation on how we would interpret due process. That limitation is that the state isn't involved. So the 14th Amendment is going to radically restructure this relationship and make the states beholden to the federal government, at least in theory, until things get going. So here we are going to see that you have the state cannot deprive person of life, liberty, and property without due process, but also they have to not hurt your rights or your privileges or immunities of citizenship, right? You can't make these ridiculous distinctions between what is a citizen and what is not in terms of the privileges and immunities that are granted. Can't play winners and losers. And the other one here is that no person cannot be unequally harmed by the law. So the law has to feel the same to everyone. And so those clauses are really critical. We see them pop up all the time in court. The slaughterhouse cases is going to be the first case in which we are going to try to get the federal government through the courts, because as you guys know, the 14th Amendment wasn't really enforced, or it wasn't codified, it wasn't turned into law, there wasn't any enforcement behind it for a very long time. And so this is the first case, though, in which a state citizen is suing the state because they feel as though they're not getting something owed to them, right? In this case, it's privileges and immunities. So these individuals in Louisiana are the kind of losing end of this deal that was put together to try to stave off cholera outbreaks in New Orleans. Cholera comes from the meatpacking industry. If you're not, if you've got runoff from the butchering of animals going into the river, you've got blood and guts and all that stuff, then you have cholera outbreaks. And so the petitioners here are going to claim that Louisiana's decision to fix this, which is to create a single place in New Orleans where butchering happened, but also to determine who's allowed to be there, to give licenses to certain individuals to continue butchering, is also making a determination that they're taking away the right to tradesmen who didn't get those licenses for them to be able to carry on their business. And that's taking away property. They believe that these economic privileges are indeed a property issue. And so they want this law challenge on substance of the law, on a substantive due process challenge. They want the courts to say, yes, the privileges and immunities should be extended, so everyone should have the same ability to be able to procure these licenses. But the court says no, they don't agree. They are going to say that this only applies to, they are really uncomfortable, first of all, getting involved in economic issues, and they really only see the 14th Amendment as dealing with issues related to race. So they're going to strike out this appeal that the privileges and immunities should be there to protect your property rights. They're going to strike that out and say, we're not going to get involved in this. This is something that the state is allowed to do. This is clearly within their abilities. The privileges and immunities are determined by the states, and we're comfortable with them excluding equal economic protections from them. Now, in the dissent here, there's going to be this suggestion that this judge is going to kind of wax philosophic and say, wouldn't it be great if we could just make the state standards, all of these individual state standards, there's very similar language across the country, but if we would just make them the same as the federal standards, so we don't have the federal standards of what these things mean, these due process rights, in addition to the various and different states. So that idea is going to be kind of around there, but that's the first time we hear this idea of incorporation. And incorporation is really taking the states and consuming them or putting them into the body of our due process rights at the federal level. So it's essentially kind of joining these two, bridging them together so that you and I, when we talk about due process rights, they're similar. It doesn't matter which level of government we're talking to. Lochner versus New York is an infamous case. This is going to come out of the courts during the Progressive Era. And so during the Progressive Era, if you're remembering, we have all of this movement to limit what big business, what our robber barons can expect from their workers. And we want things like fair pay for a fair day's labor. We want things like the ability for collective bargaining. We want all of these things. And so this guy, Lochner, who is a baker in New York, is going to take this case to the courts because he wants to sue the state of New York. They pass a law that says that you can only work a certain number of hours a day. And he says, through his lawyers, that this isn't fair, that your labor, again, is your property rights. And if you want to be able to, as an individual, slightly different than the slaughterhouse cases, right? If you as an individual elect to be able to negotiate with your boss to work more than 8 hours, who is it for the courts to come in here and to say that you shouldn't get involved? Like, if you want that contract to be 10 hours instead of 8, then fine, it's your property. You get to do with it as you want. So here, if we go back to the slaughterhouse cases we're looking at what is the state's obligations, right, in terms of creating jobs, and now we're here in terms of what are the state's obligations in removing or limiting your right to jobs. So this is going to be good for big business. And the courts are going to say that this is we feel as though it is an interference in that contract between labor and employment, which is property issue. And so they're going to strike down this law and the substance in which it's written because they feel as though this is something that they're allowed to do. And again, this would be a substantive due process case. All right, so we have that. And that case is going to be infamous because it's going to kind of encapsulate the entire era of what's going on in the courts. So we've got this progressive era legislation that's trying to expand workers' rights, and the courts are going to try to undermine that for a good long period of time. So again, just to review, substantive due process. How is the law written? What does it say? And how does it impinge or harm your fundamental natural rights? Versus procedural due process. I should go back. This is what does the law say, right? And how is it structured? Versus procedural, which is how was the law impacting it as it was expressed by the executive branches of the government. Whew, caught myself on that one. This case is really important. You guys need to put a star next to this one. Gitlow v. New York is incredibly important because for the first time, the courts are going to go back to the idea of incorporating, bridging, right, making the standards of due process, whatever those rights are at the federal level, the same as at the state level. And they're going to do it, though, selectively. So they're going to select right by right, kind of pull them out of the Bill of Rights and say, just in this case only, the states are obligated to listen to whatever the federal standard is here. So Gitlow, if you remember back to last year, this is going to be during the Red Scare of the 1920s. You've got communism going on, and Benjamin Gitlow's going to publish a bunch of socialist papers. He's going to challenge his arrest in court. This is a procedural due process clause challenge, saying that the way the law was executed took away his rights. And so he's going to win. The courts are going to say for the first time, yeah, you know what? This is a major case where the liberties are really important, and we want the state to be in line with the federal standards. Essentially, we want to erase the state standard for what due process means here. And that's exactly what they do. So Gitlow is the first time that we use selective incorporation. And again, this is kind of the second major case we're looking at, where we're looking at it through the due process clause. Going back to our friend over here, Lochner, this is a due process challenge as well, although it doesn't necessarily work out for your individual rights like you would think, kind of benefits big business. And going back, Slaughterhouse was privileges and immunities. So a little different, right? Privileges and immunities, the government's allowed to kind of decide what things they're going to give you, versus in the case of due process, it's what can the state not take away from you. Just a really important thing for us to remember as we're flipping through these things. It's Frank Palka out of Connecticut. And Frank Palka, not Palco. I know it says Palco, and that's what you should refer to it as because it's a clerical error in the court. They wrote his name down wrong. Is going to be, he steals a phonograph record player from a store, runs away on foot, and then is caught by two police officers who he eventually is able to murder with the phonograph player. The lawyers are going to go for first-degree murder. That is, meaning that he has premeditation and that he wanted to kill these police officers. Instead, they did not get the premeditated first-degree murder. They got murder 2, which means that there was no premeditation. And the lawyers were very upset, saying that, this should have been a murder 1 charge. The jury got it wrong. So they appealed. The state appealed the case. And Palco is going to challenge it, saying that this is violating double jeopardy. Like when the state loses in the court of original jurisdiction, essentially the case should be done, right? They shouldn't be able to appeal it because you're bringing somebody back up on charges when a jury of their peers, again, representation, yay, in that jury issue, has found them not guilty. So the case is over and they're done. So they want to get the murder 1. They got murder 2. Palka is going to say that's unconstitutional, and the courts are going to agree with him because he is going to contest it on the due process, not privileges and immunities. Remember, privileges and immunities are things the state gives you. Due process are things the states cannot take away. So they cannot take away your selective incorporation, Fifth Amendment rights, protection against double jeopardy. And so we have this continuation of this idea of what are our selectively incorporated rights. So after this, there's going to be a tidal wave of cases in which we're going to be bridging states, rolling states, incorporating, putting them into the body of federal standards for what due process means. The most important among them is the Warren Court. These guys did more to force states to follow federal standards than any other court out there. And this is when it becomes really important if we're thinking about when we're nominating justices, why do presidents care so much? There's this discussion that goes on with the Warren Court in particular that they became judicial activists, that they're actually legislating from the bench. And a lot of people in DC and around the states, particularly in the states, are going to be angry that the courts are now determining, they're striking down decades of of state standards for what due process means. And they want to have that ability back in the states to be able to determine what's double jeopardy, what's not double jeopardy. Can you have double jeopardy when you've got a conviction but it wasn't the right conviction, so on and so forth. So these become super important contentious issues that the courts are going to grapple with, and this is why nominating justices has in part become so politically active, why that nomination phase in the Senate Judiciary Committee is filled with fire and brimstone. Okay, so our famous court cases here that you definitely need to know each of these is Gideon v. Wainwright, Incorporation, the right to attorney for poor for all cases. Right, it used to be just that some states would just allow to have the right to an attorney for a capital case. So that's a murder case where the capital punishment is on the docket as a potential thing that the district attorney can ask for. Mapp versus Ohio is going to incorporate this thing called the exclusionary rule. You guys are familiar with this. If you don't have a warrant, you cannot include the evidence found in an illegal search in the court of original jurisdiction. So this is going to take the exclusionary rule that, forces cops to be able to get a warrant from a judge down to the states. So we're not doing unreasonable searches and seizures. Griswold v. Connecticut, it's going to create a found right. So this is the first time the Ninth Amendment is going to come into play. Again, the Ninth Amendment is kind of like our implied powers, where we say we're reserving the right to find new rights occasionally because we were really concerned that by numbering our rights, we were inherently limiting them and never allowing ourselves the ability to find them unless we actually passed an amendment, which we know is difficult. So they're going to find this right through the shadows of the First Amendment right to freedom of association and freedom of speech and things like that, with the found right against, with the given right that bars the government from forcing you to house soldiers, to the Fourth Amendment's right to bar against unreasonable searches and seizures, and the Fifth Amendment right to be able to testify against yourself and to remain silent when you're being questioned. So all of those things kind of get coupled together, and the courts say in this case that this law, it was written by the state of Connecticut, again, substantive due process violation here, was not constitutional because it unlawfully kept married couples from being able to use and access contraceptives in their personal lives. Roe v. Wade is going to extend this idea of privacy to women's right to abortion. We call this a right to predetermination when there's compelling interest of life and maternal health. And then McDonald v. Chicago, I told you this was the one Second Amendment case. This is the second of the two amendment cases, the Second Amendment cases that are going to start to limit state regulation of firearms, switching us from it being a privilege and immunity over to it being a right. And the final thing here is the Equal Protection Clause does get some play. There are lots of cases where equal protection comes into play, Plessy v. Ferguson being one of them, where we want to make sure that the courts see that we are equal no matter what, but they kind of have a weird twist here, and they say that separate is okay as long as it's equal, bringing about, oh my gosh, how many years of separate but equal, which was never inherently equal. It was always unequal. And that's where you get Brown v. Board 1 and Brown v. Board 2, where we are going to strike down Plessy v. Ferguson. We're going to hold states accountable for ending segregation by law. That's what de jure means. Brown v. Board mandates implementation in all deliberate speed. Obergefell is a case that definitely shows up that you would need to know, that has us looking at, that has us striking down state laws that make gay marriage illegal. And so Obergefell v. Hodges comes up multiple times because it is an equal protection case that allows us to strike down some of those things that have been reserved to the states, right? Marriage law has been reserved to the states. It's an issue of federalism. This showed up on last year's, on the 2017 AP exam, and the kids did not know Obergefell. You need to know it. It probably will show up again. Bowling v. Sharp is important because we are going to reverse incorporate. There's no equal protection clause in the Fifth Amendment, and so what we're going to do is we're going to reverse incorporate it, where we're going to have equal protection standards for the states and make the federal government accountable to the same things. And that is it, my friends. We are done. So yay for us. And I hope that this was helpful. If you have any questions, please give me a shout out in class.